Good evening. Thank you for joining us for another edition of Forbes India's Disrupting the Discourse. Today, we are going to understand the impact of the intermediary rules that were notified in February. Much has happened since the IT Ministry notified the rules, and the latest has been a deluge of reports that Twitter has lost its safe harbor protection. So today, we virtually sit with experts to understand what these latest developments mean, whom all the rules affect, and if intermediaries today are in compliance. Uh, we have three experts with us today. We have Nayantara Narayan, who is a disputes lawyer working as a senior associate with Phoenix Legal in Delhi. She has also represented prominent social media intermediaries such as Facebook and Instagram in several litigations in the past. We're also joined by Udbhav Tiwari, a public policy advisor at Mozilla, where he focuses on data protection, content regulation, and internet connectivity in emerging markets such as India and Brazil. He has previously worked in Google's public policy team and at the Bangalore-based Center for Internet and Society. Our final expert for the day is Torsha, who's a policy officer at the Center for Internet and Society, where she primarily works on social media regulation, intermediary liability, and digital expression. So, Torsha, starting with you, can you explain what exactly safe harbor is?
Right. So basically, what safe harbor is, it's a sort of a colloquial term for a very complicated and interesting legal framework. And what it basically means is that it gives intermediaries in this context a sort of legal immunity from acts of their users. So to sort of simplify that with an example, that would mean take Twitter. If today I post something on Twitter that is patently illegal under the law of the land, then Twitter, under the operation of the specific legal framework, would not be liable under that specific law of the land. And this is also called conditional immunity, and it's granted by Section 79 of the Information Technology Act and the IT rules that we will be talking about, which are which the government has issued pursuant to the lawmaking, rulemaking powers of the government under Section 79. So basically, Safe Harbor is asking Twitter and other social media intermediaries that you fulfill specific statutory conditions, which involves appointment of compliance officers, as has been in the news, or responding to specific takedown orders, and then you will not be prosecuted on same breath as a user doing something on your platform.
So that basically means if I am a user on Twitter and I decide to plan a crime for some reason on Twitter itself, Twitter cannot be held liable for the crime that I commit, perhaps at a later date, or perhaps I've already committed it. Is that right? That's what safe harbor would mean. Torsha? Okay, great. So, Udbhav, if you can talk about
it's
what are the
and Twitter.
Sorry, I think there was some lag. Ironically enough, our intermediaries don't seem to be working in conjunction. So please go on, Torsha.
No, that's all right. I was just agreeing with that interpretation. I think we can move ahead with Udbhav.
Okay, great. Udbhav, so what are the circumstances under which an intermediary may lose safe harbor?
Thanks, Aditi. As the sort of Section 79 of the IT Act and the sort of corresponding rules under the 79 Act say, the protection from liability or safe harbor that intermediaries enjoy is enjoyed if they fulfill certain criteria. Now, the way that the intermediary rules, the 2021 version, have been framed, these criteria have been expanded a fair bit and include both reactive obligations as well as proactive obligations. Reactively, for example, they are required to take down content within 48 hours of receiving a valid notice from a government agency or a court. They are required to share user data within a period of 72 hours once they receive a request from a law enforcement agency, and some other obligations. And proactively, they are required to ensure that they endeavor to deploy automated filtering, enable traceability of messaging content, and label, for example, content that they are promoting or otherwise making money from, such as advertisements, by labeling them as a category so that users can distinguish them. So if platforms were to not follow either of these proactive or reactive obligations, there is a case to be made that they, for that particular piece of content, they may no longer enjoy intermediary liability. However, given a lot of the conversation that's happened over the last 2 days, specifically with regard to the conversations around Twitter, but also otherwise, I think over the course of this discussion, we should really investigate whether intermediary liability is a status that is granted to you by law that can be revoked by the government, or is it a case-by-case determination that courts essentially have to make?
So going off on what Udbhav said, Nayantara, can you tell us if the loss of safe harbor status is an automatic thing? So if I am Twitter, I do not hire a chief compliance officer within the country. Do I automatically lose it, or is there some body that has to determine that? Maybe judiciary, maybe the executive.
So, first of all, your grant of your intermediary status is pursuant to your compliance of the conditions set out in Section 79 and the due diligence requirements, which are set out, which were earlier set out in the 2011 rules and now with the 2021 rules. The 2021 rules specifically have a provision which says that any non-compliance with the rules will attract the concerned laws of the land, including the Indian Penal Code. So it doesn't say that you'll immediately become liable for the content, but yes, you can be prosecuted for that content, because now if there's any amount of non-compliance, including to appointment of a chief compliance officer or a grievance officer in India, then there is a chance that you will be prosecuted.
Okay, and who assesses or whether you are compliant or not? Because there's nothing in the rules that says that METI will be the one to grant maybe compliance certificates or anything of that sort.
You're right on that. There is no mechanism which is put in place for example, if you're not complying with a simple requirement, say, of a grievance officer or a CCO. If you don't have that, it doesn't set out a procedure for you. There is ambiguity on that front because it doesn't set out a procedure for who will prosecute you, how will that status be. Now, as Udbhav said earlier, status will be with relation to one particular piece of content. It's not a blanket status. Just because you're not complied with one particular piece of content, does your immunity for all content go? That has not been the case so far, but this ambiguous sort of interpretation we'll have to leave it to the courts on this.
Okay. And Udbhav, if I can come to you for a second, you had talked about labeling content. As per the rules, any kind of sponsored content from which the intermediary itself derives financial benefit has to be labeled. But labels such as the one that Twitter uses for misleading content aren't prescribed in the rules. So what's their status? Because they have been at the heart of previous controversy vis-a-vis the kind of takedown notices that Twitter got, as well as the FIR that was filed yesterday.
Thanks, Aditi. I would say that explicitly speaking, that's a position that the Indian law is not very clear about, and that's largely because the definition of intermediaries under Indian law is quite outdated and doesn't really account for the various differing functions that different kinds of entities can carry out and still be intermediaries. Because India's sort of standard under Section 79 of the IT Act essentially speaks about editorial control, there is an argument that some people make that labeling content in a certain way involves reading it, assessing it, and then labeling it with that said label, and therefore that is exercising editorial control. And there have even been arguments made that for content like that, intermediaries should not enjoy safe harbor protection. However, even the 2021 rules are certainly not explicitly clear on that. I would say that it's one of the areas under law that is silent, and there are many aspects of law that the intermediary liability regime has been silent on, but have been allowed to proceed pretty much unrestricted. For example, the new 2021 provisions explicitly create a so-called Good Samaritan principle that states that intermediaries can take down content voluntarily if they are doing so pursuant to the criteria by which content can be removed under the rules themselves. And this is better known as community guidelines, and the vast majority of content that large online platforms take down is actually taken down because of the fact that the platform detects it either because of users reporting it or because of certain forms of automated filtering and proactively takes it down before they can cause the harm that they would otherwise cause. This was something that the Indian law was silent on until February 2021, but there were millions of videos every single year that were taken down from India by platforms, and there was no sort of like case taken against them saying that, no, you are exercising editorial control. So I think the intermediary liability regime in India by no means is comprehensive, and there is definitely leeway for subjectivity and interpretation. But to say that merely labeling a piece of content is necessarily exercising editorial control, I would say is quite an ambitious argument, and one that at a minimum will have to be seen at courts, and is certainly not something that one can presume causes a platform to lose intermediary liability.
So you talked about good faith takedowns, which are also called, which I believe is called the Good Samaritan clause under Section 230 of the Communications Decency Act in the US. So when an intermediary loses its safe harbor status, are good faith takedowns still protected from persecution, or would that amount to editorial control?
I think that, firstly, the way the Good Samaritan provision exists in the United States is radically different from the way that it exists in India. Because in the United States, those provisions are explicitly empower platforms. It's a proactive right almost that platforms have to be able to take down whatever content they wish without being held liable for taking down that piece of content, which is different from India, where it's a far more narrower provision that lets you take down content to enforce one particular aspect of the rules. So I think that distinction is something that's pretty important. No, but the second point is, I think that because of the fact that the rules themselves like envisage when you may lose safe harbor, but the term that I think like Nayantara also like spoke about in detail, which is prosecution, right? The process of prosecution is one where I first have to go to the police, file an FIR, the police investigates that complaint, decides whether the platform should or should not be a party, then investigates it, takes it to court, there's a trial. After the trial, the trial court comes up with a judgment, then it's appealed to the Supreme Court, then it's to the High Court, and then to the Supreme Court, right? Like that's the threshold that the process that one will have to follow, and the threshold that will have to be met before Twitter is held liable for a singular piece of content. So because of that, I think that presuming that just because you firstly, what does it even mean to lose safe harbor is something that actually courts have to determine in practice. The law, it says that the criminal provisions may apply to them, but it doesn't say it will necessarily apply to them and to what extent it will apply to them. And there's never been a trial, for example, where that has happened. So I think it's very hard to really answer that question, but it's definitely not the case that you have lost your intermediary status today morning, so from tomorrow you can't label pieces of content and therefore will just lose your safe harbor. It's much more nuanced and complicated than that, and it's for individual pieces of content that will take months, if not years, to play out in courts before a platform can be held liable for them.
Right. Nayantara, so you mentioned that it's not clear whether or not all content will be affected. But let's put the question slightly differently.
Okay.
I'm Twitter. I don't have a chief compliance officer right now. I may hire an interim one in the given period. But as of today, have I lost my safe harbor, which has been the main headline?
See, the interpretation that you've lost your safe harbor is coming, which is being widely reported, is coming from the point that there is a requirement to comply with having a chief compliance officer to even avail the safe harbor. If you don't have the requisites to avail the safe harbor as on date, then if there is a case, then obviously if you don't meet the prerequisites, that is going to be the major challenge, right? So it doesn't, in this case, it doesn't relate particularly to a piece of content because it's a much broader obligation which is being said that has not been complied with. So
Right. And
that's the difference here.
And going specifically by the chief compliance officer requirements, there's a proviso in the rules that says that before any liability is placed upon the significant social media intermediary, they will be given an opportunity to be heard. What does that mean?
The opportunity to be heard, I think, will play out in different forums. If there is, for example, there have also been cases about non-compliance by intermediaries which have been filed. It would be an opportunity to be heard in a court in that case. If there is a particular takedown order which MeitY is issuing and that has not been complied with, then that opportunity will be before MeitY. So that it's essentially an opportunity for them to be able to defend their actions and why they should still be able to avail the safe harbor provisions.
Okay. Torsha, so when it comes to the compliance requirements, that's for all intermediaries, not just for social media intermediaries. They may just have a slightly higher threshold for compliance. Now, does that then mean that every blog that has a comment section, is it then expected to have a grievance officer under Rule 3, which deals with normal intermediaries?
I mean, that's a good question. I am not super sure on how the government will choose to sort of interpret these provisions, because now there are three classes of entities that the Act is recognizing. There are intermediaries, there are social media intermediaries, and then there are significant social media intermediaries. But the sort of definitional thresholds that there are for the three of them are not, in my opinion, they're not very discernible. Like a social media intermediary is still an intermediary if you look at the definition, because they basically says that any service that facilitates sort of interact transmission of information between users will be a social media intermediary. So if you take that sort of a definition and you apply that to a comment section of blogs, then does that mean that the comment section of the blog is facilitating transmission of information between users? It is. Then does that mean then by that interpretation a blog would be liable to fulfill the SMI obligations under Rule 3? That's what should be expected.
Okay. And one of the things that we have discussed is what happens to all the content. This is something Nayantara mentioned. It's not as if the government or the police can suo motu start taking action against millions of videos, as Udbhav pointed out. For instance, YouTube has took down, I believe, about 100,000 or 1 million videos last year from India. So when does the loss of safe harbor actually lead to any tangible effects for a social media intermediary? Is it only after a case has been filed in court or after an FIR has been filed?
Okay, so we'll have to look at this in some parts. Firstly, let's go back to the drawing board and figure out what an intermediary has to do to avail safe harbor. Now, if your purpose is limited to providing third-party content, then that's one category. If your role is broader than that, then you're supposed to ensure that you don't initiate the transmission, that you don't select the receiver of the transmission, and that you don't select or modify the content of the transmission. And along with this, you're required to comply with the due diligence guidelines as set forth from time to time, the 2011 one and then now the 2021. Now, when you meet all of this is when you can avail your safe harbor. What are the situations in which you have to avail your safe harbor? For example, if there is a court case with regard to a particular post by a user which may be defamatory in nature, which may be impersonating someone, which is basically a problematic piece of content. Now, in the earlier guidelines, in the 2011 guidelines, and that read with Shreya Singhal, clearly sort of flagged one thing. Shreya Singhal sort of the seminal judgment on Section 79, and it noted that when it comes to private complaints, you significant social media intermediaries uh, will be receiving thousands of these complaints, and they cannot be expected to adjudicate on the legality of these complaints. Now, that was sort of the assumption in Shreya Singhal. That is the finding in Shreya Singhal, based on which they bring down actual knowledge to meaning a court order or a notification by an authorized government agency. Now, only when you don't comply with a takedown order by a court or by an authorized government agency, which is usually supposed to be a Section 69A order, that is when you are at risk of losing your safe harbor. Because that is the occasion which arises for you to lose your safe harbor with respect to a specific piece of content. So if there is an order under Section 69A requiring you to action a piece of content which you do not do for reasons best known to you, then that is when there is a prosecution there's a penalty of 7 years under Section 69A, which then will get triggered. So that is how the safe harbor sort of practically plays out. If there's a court order asking you to take down a particular piece of content, then you have to go, and then you don't do it. That's when you lose your safe harbor. So mostly what intermediaries have done so far is complied with these orders of courts or Section 69A, and that enables them to avail their safe harbor and limit any prosecution or penalty against them as publishers of that content.
So has that been expanded in any way under the intermediary rules in the 2021 version? I ask this because now law enforcement agencies, not just the 10 authorized government agencies, can also send notices to the significant social media intermediaries to either turn over content, to turn over data about the user, or to take down certain content. And that's outside of the Section 69A blocking mechanism, which is mediated via the designated officer in the IT ministry. So what happens if an intermediary says, this is just a notice from a law enforcement agency, we will not comply with it? This is not a court order. Is there any scope for that?
Interestingly, what they have done, it is a significant incremental change in the 2021 rules. In the rules, what they have said is any authorized government agency under 79(3)(b. Now, 79(3)(b) forms a part of an exemption provision, and the rules have in a way interpreted it also as an empowering provision. So that is what is problematic. They have expanded the scope of agencies which can require takedown of content by putting in this addition. So that is with respect to the agencies that can approach you. That has gone through an incremental change, and that does not find any feet in the law, because the agencies that are referred to in 79(3)(b form a part of an exemption clause. An exemption clause cannot be an empowering clause at the same time. So that is one issue. The next issue that comes in terms of expanding the scope of takedown, the rules are, as we discussed some time back, provide a clause that says if you've removed content or disabled content based on either your voluntary checking or based on a complaint by a grievance officer, you'll still be able to retain your safe harbor. The moment you say this, you're automatically tipping the scales in favor of censorship. So contrary to Shreya Singhal, you're elevating an intermediary to a super censor, and additionally, you are tipping the scales in favor of censorship, because if some content has been complained about through the grievance redressal mechanism, it would be in the intermediary's interest to take down that content, because if it does not take down that content, as we discussed earlier, the other rule which talks about non-compliance and attracting penal provisions then gets triggered. So that is where the the favorable input towards censorship comes in.
Udbhav, would you like to add something here vis-a-vis whether or not these rules actually lead to over-compliance on behalf of the intermediaries and potentially push us into a regime of over-censorship?
Thanks, Aditi. I would say that yes, it's very hard to imagine a world in which that any intermediary can claim that they are absolutely uninfluenced by like the political climate in the country in which they operate with regard to taking down content. But these rules certainly make things much worse. The fact that the rules, even in their 2011 variant, would have had a chilling effect on freedom of expression was in fact one of the criteria under which the Supreme Court sort of narrowed down some of their provisions in the Shreya Singhal case, like Nayantara has already spoken about. But even independent of that, I would say that many of the provisions that these rules now contain, such as requiring local staff that would create a certain amount of even physical risk, probably extending to the extent of jail time that could probably approach these intermediaries, but also a lot of other provisions that are very, very hard to implement with very tight timelines, such as imagine I get a video in Bodo, which is one of the recognized sort of like languages in the Indian Constitution, and I'm supposed to take it down. It will probably take me 24 to 36 hours to find someone who can translate that video, and like if not much more, and I would cross my fingers that it's not a weekend, right? So so there an intermediary will have a call just to take it down, or to and to not lose its safe harbor, or to like put in the amount of effort that one would have to do, like actively do it, which sometimes is impossible to do in the timelines that have been suggested. So I would definitely agree that like the chilling effect that these rules would have that would harm freedom of expression of users, the end sort of result is definitely the case. And it's quite likely that, for example, if a year and a half to two from now, we were to look at the transparency reports of prominent platforms and see the percentages of videos that were taken down and the quantum that were complied with, that those numbers would have increased above the typical average that should have increased in that time as well.
And are there any provisions or circumstances in which safe harbor can be reinstated? For instance, if Twitter was to tomorrow hire a chief compliance officer, a nodal contact person, and have a permanent resident grievance officer, would that then mean that it's now protected under safe harbor immediately?
I would like to sort of just like push back a little bit on that characterization. Safe harbor is not something that the government can grant or take away from you. It is something that you enjoy in law. If you violate the law, then a court has to say that you violated the law to not enjoy it anymore. And at that point in time, if you can prove that you only were violating it for a certain period of time and then you started complying with them at a later period in time again, then that again is something that the court can take into account. This broader characterization of safe harbor being something that like one person can say you don't have anymore and then everyone suddenly doesn't have safe harbor is not really how safe harbor and intermediary liability work. So I think that, is it possible that you can get that safe harbor can be reinstated? Yes. But I think in order to lose safe harbor in the first place, like the government and a law enforcement agency will have to make a case in court that you've lost it. You would then be held liable for it. And then the question of like, have you carried out actions that should mean that it would be reinstated upon you may begin. Because once again, to reiterate, you would lose safe harbor for that piece of content and not in general until there is a court or a legal process that says you've lost safe harbor. It's not something that like, if I think I'm not complying with a particular provision today, that I suddenly tomorrow morning have just lost all safe harbor. There's like laws require legal processes that state those things and arrive at those outcomes. It's not a license that can be revoked or a permission that can be removed unilaterally.
So while there may not be a granting authority in the form of, say, MeitY or a regulator like TSPs, telecom service providers would have with TRI, is the loss of safe harbor something that happens automatically? For instance, if today all journalists found out that, oh, all these intermediaries do not have a grievance officer, or this grievance officer isn't based in India, will that be enough to say this company no longer has safe harbor? Or is that something that must be determined by the court?
I mean, I think that sure, the government and or a police agency can say, therefore, this company no longer has safe harbor. But then after that, they have to go to a police station and file a complaint that says this is the piece of violating content, or this company no longer has safe harbor, and this is the content that they should be held liable for. And then the process of a criminal investigation takes place that determines the extent of that company's liability. If they had safe harbor, they would have automatically said, you can't investigate us because we are protected against safe harbor. That immediate defense that they could have literally just told that police station when they got a call saying there's an FIR registered against you may now be weaker or not present. But that entire criminal investigation process has to take place where whether they lost their liability or to what extent they lost their liability will have to be determined by a court. Like both governments and law enforcement agencies can state that it has been lost, just like you and I can say that I lose safe harbor tomorrow morning if I break one of the laws, but it has meaning in law, and the process of liability like is criminal liability for actions under the Indian Penal Code, and those are very, very different. There are some provisions under the Indian IT Act that like, where the government can fine companies and like for violating provisions of the IT Act. But if I don't enjoy safe harbor, I am not violating the IT Act. I am violating the IT Act if I don't enjoy safe harbor. I'm liable for a piece of content and still then don't do something about it. You are not required to enjoy safe harbor under the IT Act to exist as a company or as a service provider in India. So merely losing safe harbor is not a criminal act.
Okay. Torsha, I believe you wanted to add something here.
Just to sort of, I obviously agree with Udbhav regarding that legal interpretation. If you look at the construction of Section 79, the sort of immunity is built around specific transmissions per se. So the loss of safe harbor would not be in a continuum. If the intermediary is, with reference to a specific transmission, is not ascribing to aforementioned due diligence obligations, and the court finds it so, then and only then, for that specific transmission, be that either a legal takedown order that the intermediary has not complied with or something else, only for that specific transmission can you say that the intermediary has lost safe harbor. And I believe if you look at the way Section 79 is constructed, for every other transmission, it will be determined on like transmission specific basis. So I just wanted to sort of like give a sort of legal thrust to what Udbhav has already said.
I think that's a really interesting point because Nayantara also mentioned earlier that losing safe harbor doesn't mean that all content is now affected. Would it be then fair to say that effectively loss of safe harbor is felt only when a court case is filed or an FIR is filed against a particular piece of content?
Would be with
I mean,
respect.
Nayantara, please go ahead. Torsha, I'll come to you after that. Sorry.
So essentially, on that front, as Udbhav pointed out, it's not something you're required to do. Safe harbor is a privilege that you enjoy, and you will not be in a privileged position, or you will not be able to defend the fact that you are not liable for third party content if a court case is filed, or if the government approaches you with respect to a specific piece of content, or if an FIR is filed, depending on what the piece of content is. So it's not something that you have to do and you have to have. It's not a certification. It is something that is a legal defense for you. It is a privilege that you have. So so the loss of safe harbor again will not mean a blanket loss. It has to be within a construct.
Okay. Torsha, you wanted to add something.
Yeah, I just wanted to say, like, you understand how sort of safe harbor works when you look at the IP cases that has happened with copyright and trademark, where the sort of determination that came in certain cases where the concerned entity was or was not an intermediary was with the specific sort of content which was in question in that specific suit. So a specific like a audio track or a specific counterfeit product, and the loss of the intermediary safe harbor was only with respect to as the court determined with respect to that specific item on their platform. So yeah.
So to summarize what you and Nayantara have just said, would it be fair to say that an intermediary's existence as an intermediary is not entirely contingent upon it having safe harbor? So it's possible for an intermediary to exist without safe harbor as well. Torsha,
yeah. So an intermediary is an entity that's defined by a completely different legal provision within the IT Act. So and then Section 79 describes in further detail of how an intermediary functions under the IT Act. So these are completely different sections. So there is, and Section 79 also makes provisions for when an intermediary may not have this safe harbor. So to answer your question, I think that there can be possibilities where an intermediary can exist without safe harbor, but I don't believe that it's something that would be in like a continuous. It's not from here to eternity that an intermediary will not have safe harbor. It's any sort of taking away of that privilege would be with reference to specific transactions or specific pieces of content. So that's that is how I think I would interpret the law.
Okay. An interesting development that also happened on May 31st was that Delhi High Court said that Twitter will have 3 weeks to file a reply about its compliance status after a petition was filed against Twitter. So does that mean that Twitter has essentially got 3 extra weeks to comply? Udbhav?
Like, both yes and no. If I was Twitter, then I certainly would be giving that like order from the Delhi High Court to the government in an email, like I would have sent that today morning to say that the court said that we had 3 weeks to be able to do this. But I think that like the order definitely, from what I recall, definitely did not say that like you therefore don't have that, therefore you have 3 weeks to comply. It said that you have 3 weeks to tell us what you've done. So it's, I think, a legal gray area that like both parties can use to their strategic, by both parties I mean like Twitter in that case and the government can use to like their strategic advantage. But in practice, like if Twitter has not appointed those functionaries yet, then yeah, there is definitely a provision of the law that they have not complied with yet.
Yes. Nayantara, you have represented big tech in the past. How would you approach that order, which as Udbhav also pointed out, doesn't actually say that you have 3 extra weeks. It just says that we grant Twitter 3 weeks time to file a short reply or counter affidavit.
I believe that the purpose of the counter affidavit is to explain what the compliance is, what stage the compliance is at. If there are reasons because of which it is taking time to comply, and it's not like the government has not acknowledged that these new obligations for significant social media intermediaries do not require time. The rules came in on 25th of February and then provided 3-month period for significant social media intermediaries to comply. If it requires some additional time to comply, then I think that that argument to request for that additional time to comply either before the court or before with METI is a plausible one. Especially considering that you would basically have to explain your stance as to why it has taken this time.
Right.
It
So
can't
one is
be.
the court.
I mean, as it is being phrased, it can't be. I mean, a lot of media reports seem to suggest that it's some kind of wanton disregard for the law. I mean, that is one flavor that the media is putting to it. But at the end of the day, if there are practical difficulties, if you are in the process of complying, if it takes you a little longer, then that's something that the government can accommodate for.
Right. So one of the reasons that I have heard a lot about why it's been harder for companies to comply is because, at least as the chief compliance officer, the rules place personal liability on the chief compliance officer. So does that mean the chief compliance officer can be arrested in case the significant social media intermediary is not following the due diligence requirements? Nayantara, please go on.
Okay. So the concept of liability on key managerial persons is not something which is new to either the IT Act or generally to the legal jurisprudence in India. Because the section 85 of the IT Act does say that, if there is some kind of contravention of the act, that you can look at people who are currently in management. So it is of course an incremental change, but that concept of personal liability is not something that is out of thin air at this point of time. And irrespective of whether or not that liability is out of thin air, the point is that for that liability to accrue, there's many a slip between the cup and the lip. You can if there is an FIR, the managerial person can approach a court to ask for protective measures, to ask for no coercive steps to be taken against them. There are a lot of steps that you can take before that liability is cast upon you. So it is not as magical as, if there is a problem tomorrow somebody is in jail. That's not how it works. So if there is non-compliance, you will first have to see what kind of non-compliance is it. What are the ramifications of such non-compliance? Like, for example, if you are not complying with a court order which requires you to take down a particular piece of content, which is, say, defamatory. So if you've not complied with it, you lose your safe harbor. Now if that's if the order that was passed by the court is an interim order, then obviously no final determination as to whether the content is defamatory or not has been made. Except this will be either in a civil defamation suit. Then whether criminal proceedings have been initiated with regard to the same piece of content. If so, what is the stage of those proceedings? So the liability between non-compliance and liability, there's an entire gamut of events that has to take place for somebody to end up in jail.
Okay. Udbhav, do you want to add something here, especially because, for instance, since morning, Internet Freedom Foundation has said that it's the process itself that is the punishment, and that is what is a factor of intimidation, and what the UP police or the Ghaziabad police did with the FIR is problematic.
I would say, before really getting into that, I think that we should also keep in mind the context why India has like an intermediary liability regime too, right? India has an intermediary liability regime because there was a website called Bazi.com where you could anybody could sell things similar to how platforms like OLX operate right now. And there was some sexually explicit material that was being sold on that platform, and the police landed up at the MD's house of that platform, arrested them. The Delhi High Court, because at that time there were no provisions around intermediary liability, said that that person was guilty and the company was guilty. And then the Supreme Court eventually ended up overturning that decision in 2012. Because of that broader sort of framing, we should keep in mind that it may seem like a nice way to ensure that content is taken down in terms of coercive action, but there are many. It's quite a far away step from taking company law with regard to the liability of directors for the actions of a company and the scale at which the internet operates, and imposing personalized liability upon platforms, upon the heads of these platforms. Even countries like Russia, now Turkey, don't impose criminal liability upon the heads of these companies. They fine them incredible amounts of money any day, say that they can be blocked, and say that there is the possibility of criminal sanction being taken against the companies. But going after individual people who are responsible within the company for the activities that we are discussing is a particularly coercive way of enforcing this action that broadly in the intermediary liability regime all around the world is, I wouldn't say unique to India, but it certainly as a threat is waived very frequently in India, and that's definitely something that we should keep in mind.
So it's interesting that you brought up the Bazi case, especially because Bazi was an online marketplace, and online marketplaces are defined as intermediaries under the Parent Information Technology Act. So something like Amazon or a Flipkart or even potentially Zomato is an intermediary. So what are the compliance burdens on a Zomato as a platform, as a marketplace, and then for its comment section, which enables online interaction between two or more users?
I would say that there are some instances of the intermediary rules that I don't think would really apply to the online marketplace aspects of Zomato or Amazon, like traceability of messages, for example. I can't imagine, as a platform, sure, there may be places where you have to trace messages, but if you're selling a product, I don't know what you would do enabling traceability there. And then that's just one of them. I think our provisions, there are some provisions that apply to them equally much. For example, I think labeling promoted content. Advertisements in e-commerce platforms such as Zomato and Amazon, there's clearly now a requirement if they want to enjoy safe harbor to do that, if they're promoting products that people are paying money for. I think on the comment section, there is a distinction, I think, and it's one that's not really been dealt with properly in the rules because of how vague the definitions are around whether you are a social media intermediary or not. So I think a lot of the provisions around significant social media intermediaries in practice are sort of going to be dealt with, hopefully in court, maybe if the regulation is improved in the interim, because there are many entities that perform social media intermediary-like functions, such as allowing you to chat with a customer agent because your burger hasn't been delivered, but it's very hard to imagine in practice that you would expect them to follow the same obligations that you would expect a WhatsApp or a Signal or a YouTube to follow. So because of that distinction, I think that some platforms may err on the side of caution. I think that the vast majority of them will just wait for that request to come. And if it comes, they will see what they have to do with it, because it doesn't make any sense to invest the money and the resources that you would have to comply with some provisions when you aren't really a social media intermediary, and the odds of those threats taking place on your platform are quite low too.
So it's interesting you mentioned again the labeling content requirement, and that's only for significant social media intermediaries. So for Amazon and Flipkart to have to comply with that, they would have to have more than 50 lakh registered users and be a social media intermediary. But as you said, the fundamental question is, are they a social media intermediary? So
it's probably much easier to say that they're a significant social media intermediary than some of the other platforms like Zomato and Dunzo that we've discussed. I'm just saying this because comment sections on Amazon are a world onto their own. There are a lot of things that take place there and things that are said there, that if a government may want to make a case that you are one, I think it's more likely for some platforms than it is for the other. But that doesn't mean that it's fair or reasonable. We just need a better definition of social media intermediaries in the rules.
Okay. So Nayantara, in your opinion, would Amazon, Flipkart also be social media intermediaries? And given the scale at which they operate, will there be significant social media intermediaries?
I think the objective of the rules is strictly to deal with the user generated content, and to deal primarily with platforms like Twitter or Instagram or Facebook, rather than to deal with Amazon. I think probably of course, as he said, it's possible for that interpretation to be brought, but I don't think that it would be worth their money to put that back into it right now, especially if that case is not being made out so far.
So one of the main incidents that happened this year was, of course, the infamous toolkit case, where the toolkit, which often we also create to design our marketing plan for an article or something of that sort, was written and shared on Google Docs. Now, Google Docs are also a social media intermediary under the definition. And if do you think the definition in that case is expansive? Because going by the literal definition, it appears that email services, even if, say, a company needs to talk to Amazon Web Services for troubleshooting purposes, would make it a social media intermediary function. So do you think it's too expansive?
One thing that you have to keep in mind is that these definitions date back to 2000. And in addition to that, it's common practice to have wider definitions so as to catch something in the net which may not, because technology is evolving at a much faster pace than our legislative developments. I mean, for example, if you just look at the due diligence guidelines, the first the ones prior to this were in 2011, and now it's in 2021, so it's almost it's 10 years since you've evolved from the last legal position. So these broad definitions are not something that's unique to the IT Act. Of course, they've been placed with the view to sort of keep pace with changing and evolving technology. So rather than to lose out on sort of implementing it from the government's perspective, if you think about it, it's rather than to lose out on implementing it, you would rather have a wider definition than a narrower definition.
Torsha, do you want to add something there?
I mean, from a standpoint of a legal researcher, I think these definitions are definitely pretty broad, especially like I've already mentioned, the distinction between SMIs and intermediaries is literally redundant because it's facilitating transfer of information between users, which can be like all the examples that have been mentioned priorly, that can encompass a vast amount of entities, including Amazon, including Flipkart, and even Zomato. And same goes with the sort of distinction between an SMI and a significant social media intermediary. There is a user threshold, but the user threshold, it's not clear how that determination is going to be made. It just says 5 lakhs registered users. It does not say the way the government is going to determine this, if it's going to be daily active users, it's going to be monthly active users. So, and the threshold is like surprisingly low for a country like India with the amount of internet users that there is. So it's an expansive definition, no doubt, and the intention was for the government to regulate specific entities, but it does not really stop in the future for cases where this is extended to other entities as well. So yeah.
Right. So because we are running out of time now, I wanted to ask you, what's the way forward from here? How do we proceed now that the rules have been notified? Do they protect users? Do they protect citizens? I think there's consensus around the world, in fact, right now, that these rules are violative of fundamental human rights, especially right to privacy and freedom of expression. So where do we go from here? Udbhav, if you want to begin, especially because you're part of Mozilla, which is a non-profit entity.
Sure. I mean, I think that in terms of the way forward, I don't see a world in which like these rules aren't at least to some degree successfully challenged before courts over the period of like the next 2 to 3 years. It's clear that if they were to achieve some of the intentions that they've set out to achieve, that would ideally have to happen as a part of a much larger project to like update the IT Act and bring it and make it relevant for the sort of like modern age. And that is a process that I think the government has been speaking about for some time, is very much ongoing. But until that happens, I think that what has been attempted to do with the rules and what is possible legally to do under the rules and what they're actually used for are all like quite tenuous right now. But apart from that, I think that one must also keep in mind that like the large part of the framework of these rules is largely present to be reactively and strategically enforced, right? This is like, while they contain proactive obligations, I think it's when we like reach certain critical junctures where like political context, social discourse, and like the role that technology is playing in it like come together, is when I think these rules will be the most strategically utilized. And that is going to be their true test, both not just in courts, but also to their impact that they're going to have on like the fundamental rights of like Indian residents. And because of that, I think that like we are already starting to see that happen almost on a weekly basis, actually, ever since these rules have come out, that there's something happening. But like I think those are, in comparison to some of the larger conversations that have to happen around it, like blips in the radar. And it's very clear that like the courts have a lot to say and do with regard to how these rules should operate, and I'm looking forward to them doing their job.
Torsha, where do we go from here?
So, in addition to what Udbhav has already said, I think what India has come up with these rules, they should be contextualized in the backdrop of similar examples across South Asia. You take Pakistan's law, or you take Bangladesh's law, and across Asia and the world itself. There is a sort of growing discontent and confusion around the way intermediaries seemingly exercise on the internet without any accountability and without any power. And all of these laws, including India's laws, to me are sort of this a flawed way of reckoning with this, a flawed way of dealing with this. And one way in which perhaps we can move forward from there is to try to look beyond this simple legal adversarial position of taking down content versus retaining content, and try to understand moderation of speech, or the issue of digital expression on speech, as a much bigger holistic issue which has many participants, including women's rights, including marginalized communities, including children's rights. So, and the government has avenues for doing this. The government can go beyond fixing, like you have said, reactionary legal obligations, and try to bring forward a multi-stakeholder understanding of the internet. So yeah, I think I'll stop there. I realize it's super ambitious and hypothetical, but that's just the hope with which I want to look forward to this issue. So.
I think we can all deal with a few doses at least of optimism and hope. So, and idealism. So that's not a problem. But do you think a lot of legislation around big tech, at least in India, is aimed at bringing non-Indian big tech to heel rather than protecting citizens or protecting the integrity of public discourse or public conversation?
I mean, there is, if you actually look at it in the South Asian context, there is some sort of suspicions against big tech and to some extent to international media. So, and this is a point that has been repeated again and again in this interaction between government and Twitter, that Twitter is a foreign entity who is not listening to Indian law. And like that's a sort of narrative that the media has also taken into account. So there is a definitive attempt to do that, for also the reason that it is easier to bring an Indian company who is registered and incorporated in India in compliance with the Indian law than a foreign company. So those conflicts, I think, have also been heightened because of these reasons.
Right. Nayantara, final comments about where we go from here and what it means for big tech.
The significant social media intermediaries and the obligations cast upon them are of course a very significant increment from the 2011 version, because that concept altogether has been introduced by the 2021 Act rules. The key things to look at, for example, the proactive sort of identification of content which is rape, child sexual abuse, or content which has previously been taken down via a court order or a government notification. That and deploying technology for that, that is to me a very interesting point, because the rules seem to be very aware of that, the fact that it will have ramifications in free speech and privacy of users, and that being aware of that, that it's put in as a proviso. But how does it practically play out is something that we will have to see. Can you really delegate such, if you have to track down content which is, say, rape content or child sexual abuse content, would you have to monitor everything? That again, the same logic applies to when you come to traceability. If you're looking at requiring traceability and requiring the first originator, again, something that the original act does not have, the concept of a first originator. If you're going to mandate such a requirement, what is the ramification? It merely has one proviso which says if no less restrictive means is available. What does that mean? What is a less restrictive means? And when can this be exercised? And is the exercise of it even practical? Because if you are looking at platforms, many of which are end-to-end encrypted, does it mean that to comply, of course you have put a threshold of higher crimes and heinous crimes that you've put a threshold for, but to identify that, do you need to completely overhaul the entire system, thereby affecting everybody's right of right to privacy or everybody's daily interactions? Another aspect would be whether, with respect to content which is maybe not problematic, if there is a requirement to sort of overhaul your systems, then what is there a right to anonymity? Again, something that the court will have to sort of adjudicate on. There's a lot of ambiguity in the rules that is there, which either the courts will have to intervene and clear up, or may not stand the test of judicial review before a court.
So it appears that we are in for a lot of litigation in the future, either filed by big tech, as has already happened with Google's petition, with WhatsApp and Facebook's petition, or by through interventions by civil society organizations. But it appears that there's still a lot that needs to be clarified vis-a-vis the rules. We haven't had any FAQs that have been released by the IT ministry, as were released by the Ministry of Information and Broadcasting with respect to digital news publishers and OTT platforms. So there are things that need to be clarified. It appears some of these questions will still persist. We'll still keep getting new headlines every day that this company is in compliance or this isn't, and the government is now cracking down. So it's not an entirely optimistic note as Torsha would like for us to leave on, but it's given us a lot to chew on. Thank you for joining us. Thank you, Udbhav, Nayantara, and Torsha, for joining us for this edition of Disrupting the Discourse. And we'll keep coming in with more editions of Disrupting the Discourse, discussing what are the latest developments, inviting experts. And if you have any questions, you can always tag them with #AskForbesIndia. Thank you and stay safe.